we are now ready to start the webinar. So we're going to, this afternoon, we're talking about privacy notices, and really what we're going to be talking about is what the situation is now under the Data Protection Act, and how that's going to change under the General Data Protection Regulation that comes in from May next year. So, that's what this afternoon is all about. It's about what you have to tell people about the personal data that you're collecting from them and about what you're doing with it. So, start off with, let's look at what the Data Protection Act requires. First data protection principle says that personal data should be processed fairly and lawfully. And what the Data Protection Act says is that you can meet the fairness aspect of this primarily by providing data subjects with a statement explaining how their data is going to be used. And in the Data Protection Act, over in Schedule 1, it does explain what you need to include in that notice, and that's summarised on the right-hand side of this slide. So you can see here that at the moment, under the Data Protection Act, what you're expected to provide is information about the data controller, if they've got anybody who represents them, so maybe if you've got a contractor who's carrying out work collecting personal data or using personal data on your behalf, and you have to explain what you're going to use that data for, so what's the purpose of collecting the data, and you also have to provide any further information necessary to make the use of the data fair. Okay, so really just 4 things there listed in the Data Protection Act that you have to provide to people. And you have to do this whenever you're collecting personal data, or indeed if you've already got personal data but you want to do something new with it that people wouldn't have expected. And the best thing to do is to provide it in the medium that you're collecting the data in, if that makes sense. So I'll illustrate this with a few examples. So in the first point, probably something you're very familiar with is if you're filling in a paper form, very often there is a statement at the bottom of that form or at the top of that form or somewhere on the form which explains what's going to happen with that data. Too often, of course, it's complete gobbledygook and we don't understand what they're saying. Very often it's hidden away, but really what the point of that is, it's supposed to be obvious and it's supposed to be telling people what you're going to do with that data. So if you're collecting information on a paper form, the best place to put your privacy notice is on the form itself. If you're collecting information by telephone, what do you normally hear if you call the utility company? If you want to use the chat box just to respond and tell me what you remember hearing if you call your local utility company or something like that, what is the first thing that you generally hear? Anybody remember? Absolutely, Andrew. Yes, you normally hear a statement, something along the lines of that. So calls may be recorded for training and monitoring purposes, or whatever it is. And what they're doing there, of course, is they are giving you a privacy notice. They're giving you a privacy notice to explain how they're giving you a privacy notice to explain what's going to happen with the data that you provide, and indeed the data that's being recorded. So you're getting a privacy notice. If you're collecting data online, then you should design the way that you give a privacy notice to suit the medium. rather too often, one of the problems with online privacy notices is that very often you will get a privacy policy rather like the one on screen here. And these days, the most common way for people to interact with websites is actually via a mobile phone. And of course, mobile phones, you know, various sizes, but generally speaking, we're talking about a smaller screen than we used to be looking at things on. And so, if you've got a privacy policy in the form that we've got here, it's actually quite difficult to read. And most of us, if we had to go scroll through 8 pages and zooming into the detail of this policy, we may choose not to read that privacy policy. So it's arguable how useful it is. So one of the things that we'll talk about a little bit later this afternoon is about how you design your privacy policy, particularly on a website, in a way that will make it easy for people to follow, that they are likely to read. And of course, another way that personal data is collected is via CCTV. If you have CCTV in your building, or you walk down a street where there's CCTV, you will usually see, or you should see, a sign which looks maybe something like this. So you might see a symbol advertising the fact that CCTV is in use, and it will provide certain information. Now, if you think back to what I said a few moments ago about what has to be in a privacy notice, you'll note that on this sign it has all the things which have to be in a privacy notice. So it says who the data controller is, in this case the School of Oriental and African Studies. It says what they're going to use the data for. So it says images are being recorded for crime prevention and detection, as well as health and safety purposes. So it explains the purpose. And it provides other details to make its use fair. So it explains that it gives you a contact number and a full address if you want to get in touch with them to make inquiries about the CCTV system. And it provides details about when it's in use. So what that CCTV sign is doing is it is acting as a privacy notice. It's providing all of that information which the Data Protection Act currently requires that data subjects are given when you collect data from them. Now, all of that is fairly straightforward. Just a reminder, of course, if you've got any questions, if anything I say doesn't make sense, do send me a message using the chat box. But basically, what I've described so far is how things are under the Data Protection Act, but we are on the verge of a major change, the first major change to data protection law for 20 years. And that change, of course, is in the form of the General Data Protection Regulation, which was actually adopted by the European Parliament and the European Council on the 27th of April 2016, as you can see here. And that regulation comes into force on the 25th of May next year, 2018. It's getting closer all the time, and of course we need to be preparing for that. Now, what we need to look at is, of course, what GDPR changes in terms of giving people privacy notices and giving them information about how their data will be used. Transparency is a really important concept within the GDPR, you can see here that in the recitals to the General Data Protection Regulation, basically being a European regulation, it's structured slightly different to to the UK legislation that we may be familiar with. Recitals are at the start of European legislation, and they kind of give the background. They explain what the aim of the regulation is. They explain how the rest of the regulation ought to be interpreted. And so, looking at recital 39, it says it should be transparent to natural persons, so that's individuals, that personal data concerning them are collected, used, consulted or otherwise processed, and to what extent that personal data is or will be processed. So basically it's getting in there right from the start of GDPR how important it is that people understand what's going to happen with their data. If we move on to the data protection principles, just as with the Data Protection Act, there are data protection principles in the GDPR, and in the principles in the GDPR set out at Article 5, the very first principle requires that personal data use is lawful, fair, but also transparent. The lawful and fairness part, you'll remember, from a few moments ago, that was in the first data protection principle, that is in the first data protection principle that applies at the moment. But in this case, the word transparency is actually part of that principle as well. It was implicit in the Data Protection Act, but it's now explicit. This is an important part of that first principle. So again, it's really reinforcing the fact that transparency about how personal data is used is really fundamental to the GDPR. And once again, if we move forward to Chapter 3 of the GDPR, the articles there set out the various rights that people have under the General Data Protection Regulation. And you'll see, once again, the very first one that's highlighted in GDPR is transparency. So the right to be told what's happening with your data. So this is something that's really important. It's really reinforced even more than it is under the current Data Protection Act. And really in line with this, there in Chapter 3, Article 12 of the GDPR talks about the fact that controllers have to take appropriate measures to provide information to data subjects. And it also stresses that information should be provided to the data subject in a concise, transparent, intelligible and easily accessible form, using clear and plain language. And it particularly stresses that if there are, if children's information is being collected, that they should be able to understand what is being done with their data, what the implications are for them. So that really is just reinforcing this whole point about being clear and using plain language. Now, some of this may seem a little bit contrary, perhaps, to what Articles 13 and 14 say, because as we'll see, what GDPR spells out is that when you collect information from people, whenever you use personal data about people, you have to make sure they have access to a great deal of information about what you're doing with that data. So how you do that in a concise, transparent, clear and plain language way is one of those challenges which GDPR poses for data controllers and for data processors to a certain extent as well. So really just to illustrate this, on the left you can see what you're required to provide at the moment under the Data Protection Act. So again, detail the identity of the data controller, identity of any representative, what you're going to use the data for, and any further information that you believe is necessary. There's a lot of, with the current Data Protection Act, basically it's not spelling out in detail what you have to provide people. It's allowing data controllers a certain amount of discretion about what information they provide to data subjects. If we look at the list on the right, though, you can see that there's an awful lot more information which the GDPR requires you to provide to data subjects. And really what's happening here is that the GDPR is specifying in much more detail what it is you have to provide to people. So if we have a look here, what I've attempted to do here is summarise what it is that GDPR requires you to tell people when you collect data from them. And you can see it's a much longer list than under the Data Protection Act. Having said that, it does break down into some pretty obvious groups, and those groups are actually quite similar to what you had to provide under data protection. It's just that it's specifying it in much more detail. So whereas before it said you had to provide the identity of the data controller and the identity of any representative, you'll see on the top left-hand side of this slide you are now required to make sure that you provide information to data subjects about the data controller, and you're also still required to provide details of the representative. But you'll see here it specifies you have to provide contact details as well, and it also specifies that you have to provide contact details for your data protection officer. Data protection officer obviously being a big change in GDPR, that many organisations will be required to have a person with a formal role of data protection officer, and so very much the case that and this is reflected in the details that you have to provide to individuals. You have to explain to them who the data protection officer is, so that they can get in touch with them if they have a question, if they have an issue. So that first part, there is some similarity with the Data Protection Act, but as I say, it's kind of expecting a bit more detail to be provided. If we go down to the bottom left corner of this slide, you'll see that you have to provide a lot of information about the purpose that you are collecting the data for. So with the Data Protection Act, you had to provide information about what you were going to do with the data. You had to explain the purpose. But here, again, it's specifying in more detail what information you have to provide about the purpose. So you have to explain what you're going to use the data for. If you're going to use that data to make automated decisions, or indeed to profile individuals, so for example supermarkets at the moment have these sort of cards where you can collect points, and of course that information is used to profile customers' shopping habits, and that's obviously useful to the supermarkets. But often one of the criticisms of that in the past is it hasn't been very clear to customers what's happening when they sign up for these deals and these schemes. In the future, they will have to be a lot more transparent about what's happening with that data and how it's used to make decisions and how it's used to profile those customers. You'll have to explain the legal basis for using the data. Now, one of the things with data protection is that as well as providing information to people about how their data is going to be used, you also have to justify your use of data by use of one of the conditions in the Data Protection Act at the moment, or set out at Article 6 in the General Data Protection Regulation. Now, those conditions include consent, of course, but also a whole range of other conditions, including the legitimate interests condition, which is where you've identified a specific purpose, a specific reason why you need to use somebody's personal data, which isn't reflected by one of the other conditions. If you've identified a legitimate interest, you will need to spell that out in information that you provide to the data subject. And you will also have to spell out, if you're relying on any other conditions, you'll have to explain that to the data subject. So it should no longer be a mystery to the data subject what basis you are using the data under. At the moment, I think it's probably fair to say that many organisations, it's a bit of a mystery what condition they are relying upon. So this may be a bit of a move forward for organisations as well as the data subjects whose data they use. So we're going to have to be much more transparent about the legal basis. And also you'll have to be more transparent about what categories of people will receive that data or have access to it. And that's going to include, of course, your employees. So if people, you're going to have to be clear in your information that you provide to people, whether that be in a privacy policy or privacy notice or elsewhere. You're going to have to be clear who it is that's going to have access to the data that is provided. And then, just as with the Data Protection Act, it said any other information which is needed to make the processing fair, the GDPR says that other information is required, and it specifies particularly that information should be provided on any international transfers of data. So if you store data in the cloud with a company that's based overseas, if you transfer data to an organisation that's based abroad, if you are a company that is based an international company with sort of a head office in another country, and you have to share data with other parts of your company, you will need to make sure that that is clear in the information that you provide. You'll also have to provide information on how long the data will be stored for. If you don't know how long you're going to store the data for, at the very least you'll have to explain what criteria you will use when deciding how long you're going to keep that data for. So you're going to have to be a lot clearer about how long you're keeping data for, and you're going to have to be a lot more transparent about how you make that available. About how long you're going to keep that data for. And also you will have to be clear with people whether it is essential for them to provide the data that you're asking for, and if they don't provide that information, what the consequences of that will be. Will they lose out in some way if they don't provide that data? Or if they didn't provide it, would it make no difference to the service that they receive? You've got to be clear about that. And then finally, one of the things that the GDPR says that people have to be provided with is information about their rights. So they have to be reminded that if they have given their consent for you to use their data, that they have the right at any time to withdraw that consent. So they have to be reminded of that fact. Furthermore, if you are you also have to remind them of their other rights, so the right to be able to access information by making a subject access request, the right to be able to correct information, the right to be able to erase information, or that they're sometimes referred to as the right to be forgotten, the right to restrict the use of data, the right to object to the use of data, the right to be given data in a portable format that can be transferred to another service provider. And also, very importantly, they have the right to be you need to remind them of their right to complain to the Information Commissioner. So all of this is information that data subjects you are expected to tell data subjects when you collect data from them. Given what I said earlier about the fact that this has got to be done in a succinct form, in a concise form, in an easily digestible form for the data subject, that's going to require some creative thinking. Article 14 of GDPR explains what you need to provide if you've obtained the data from another organisation. So Article 13 is what you provide when you're collecting the data from the data subject. Article 14 is when you've got the data from some other source. If you've received it from some other source, then you are expected to provide the same information to data subjects within a reasonable period. And they specify in GDPR that a reasonable period will be no more than a month. And you also have to explain the categories of data which have been passed to you. So the categories of data that you will be using, and you have to say where you got that data from. You don't have to do this if the data subject already has that information, so presumably this covers situations where the company that gave you the information, they had already told the data subject that they would be passing the information to you. If it would involve disproportionate effort, or it would be impossible to notify the data subject that you've been passed this information, so that's another circumstance where you don't need to do this. And then finally, if there's some sort of secrecy obligation, so perhaps in circumstances where perhaps there is some sort of professional confidentiality in place, legal professional privilege, maybe medical confidentiality, which prevents you from informing the data subject. But in all other circumstances, you'd be expected to let the data subject know when you've been passed data. And just going back to recital 58, all of that is going to be quite difficult given that we're supposed to be being concise here. So let's take a look at some ways to do that, and we have got some help with this. Actually, ignore the fact that it says consultation on the left-hand side here, and that code of practice is now available on the Information Commissioner's website, and there is now a new code of practice on privacy notices, transparency and control. And the use of words there is deliberately chosen. This code of practice is meant to reflect the requirements in GDPR and is really reflecting the fact that GDPR is about giving people more information about how their data is used and also giving them more control over what happens with their data. And you can see from the chapter headings in this draft code of practice, they're slightly different in the final code, but actually this gives you a better idea actually of the coverage of the code. So you can see from this that that the subjects covered in that code are designed to take into account what's required in GDPR and are also required to reflect changes in the modern world. So you can see here there's headings around the Internet of Things, the idea that more and more gadgets are connected to the internet these days, and of course that means there's implications in terms of where data is going, people who can access that data, and chapters on selling information, chapters on how you go about this. Now, bearing in mind that GDPR requires information to be communicated in a succinct manner, one of the tools that the GDPR talks about is the use of icons and symbols, and you can see that there's a chapter heading on that within this this code. And one of the things that is likely to be forthcoming in the next year or so are some sort of standardized symbols and icons that can be used to communicate very simply and concisely to users what's going to happen with data in a particular circumstance. So various common circumstances where data is collected, there will be special symbols that you can use on your literature, that you can use on your website to indicate to people, right, if you provide this data, this is what's going to happen with this data, and it will be a commonly understood symbol. But there are some other things that are mentioned in the code, and let's just I'm just going to go through briefly some of the themes that are mentioned in the code and that you might want to explore a bit further after this webinar. So one of the things that is emphasised in GDPR and is definitely emphasised within the Information Commissioner's new code of practice is that there is more of an emphasis on pushing than pulling. At the moment, so what I mean by that is that at the moment, when we want to find out how an organisation is using our data, we have to go looking on their website very often. We have to go looking for the privacy notice, whereas the emphasis in GDPR and in the new code is on making sure that people can't miss those notices. So we put them in prominent places as part of our website, as part of forms, as part of processes that people go through, so that they can't avoid knowing what's going to happen with their data. So, so that would be, so you might see, and one of the things you probably saw in that list of contents a moment ago was reference to just-in-time notices, and there's much more emphasis on that. So that's the idea that when somebody is filling in a form, it might have a sort of a notification, a notice that comes up, rather like the sort of cookie notices that you see now. But you might see some sort of little dialog box coming up saying, by the way, this information will be used to contact you in future about this service, or something like that. So basically, you know, they're given that information at the point where they're entering the information in. So there's much more emphasis, as I say, on pushing this information to the user rather than expecting them to go searching for it. And with that in mind, one of the things that the Code of Practice emphasises is the importance of planning your privacy notices, of designing them. You need to think carefully about how people use your website, for example. So how do they access the parts of your website where you collect information? Is it when they go to the website, will they always see the privacy notice, or could they inadvertently miss that privacy notice? You need to make sure that it's always, that whenever anybody is going through a series of web pages that's likely to result in them providing information, that you've made sure that they are able to see information about how their data will be used. So you need to think that out in advance, map it out, just as you would any other process on your website, any other important process on your website. Map it out, and you might want to test that process. So test how people use your website, and see whether they see those privacy notices, are they prominent enough, and does it affect the way they use your website? Does it lead them to make decisions about whether or not to provide that information? So you need to think carefully in many cases about the way your website is designed, and that's one of the things that the Code of Practice talks about. Also very important to consider the way that you speak. As we saw earlier, the GDPR requires that privacy notices use plain English, one thing we have lots of guidance on in this country is how to use plain English. We have a plain English campaign, of which the symbol on the right-hand side of this slide that's their symbol, of course. And what you should be aiming to do is make sure that any information you provide to data subjects about how you use their data is in plain English, so that they can easily understand it. Too often these days, when you look at a privacy policy or a privacy notice, it's very legalistic and it's very, very difficult for the layman to understand. Need to avoid that, make sure that it's easy to understand for people. One good and a tip in the Commissioner's Code of Practice is to try and align the way that your privacy notice is written with your house style for the design of your website and other media. So it might be worth talking to your in-house communications team, if you have that, so that they can advise you on the best way to communicate your privacy notices. A concept that was in the old Code of Practice on privacy notices and that has survived into the new Code of Practice is layering. If we think back to earlier on, and I showed you that privacy notice which appeared on a mobile phone as having about 8 pages of very small, very dense text. The way to deal with that in the context of websites is to use a concept called layering. and this is recommended by the Information Commissioner's Office. And really what they say about this is that what you need to do is have basically have a very basic notice at the point where people are just entering their information. So it might say, in very basic terms, if you provide your information here, it will be used to contact you in future about our services. So you might have like a one-line statement summarising what you're going to do with the data, and then provide a link to more detailed information elsewhere on the website. So making sure that you have all of that other information which was detailed when we were talking about Article 13. So all of that extra information about how long you're going to keep it for and all the rest of it, you might have in a more detailed privacy notice elsewhere on the website, so that the casual user, if you like, isn't being bombarded with information that they're perhaps not interested in, but they are getting at least some basic information about how you're going to use their data. So you need to think about how people are going to read these privacy notices, how are they going to encounter them, and bear in mind the fact that they may be accessing them, particularly if it's information on your website and they may be filling in forms on a website. You need to think carefully about the fact that they may be reading this on a very small screen, and you want to avoid, when you're designing your privacy notice, you want to find ways to avoid people having to zoom in to read your privacy notice. So you can use layering to break down your privacy policy into perhaps smaller pages with less text on that people can read realistically on a mobile phone screen. You also need to consider accessibility. Bearing in mind that perhaps children may be reading this website, you may be collecting information from children. Certainly in the UK, it looks like children over 13, they'll be able to provide in law information, and you will need to consider their needs when you are designing your websites. Also consider other vulnerable individuals, maybe people with learning difficulties, people maybe elderly people or people with a disability. Consider their needs as well as everybody else's needs. So you need to make sure that you consider that in the way that you design your websites. And you may even need to consider things like whether the people who are using your website, perhaps English is not their first language. So you may need to, bearing in mind it might be children using this, it might be people with perhaps eyesight problems, it may be people who have limited understanding of English. You need to make sure that your privacy notices are written in a form that is simple to understand. Hopefully one of the things that will help with that will be these icons, these symbols. Once those are in use and people and those are widely recognized, they will help organizations to communicate the message of privacy notices to people who speak a range of languages, particularly across Europe. People will be familiar with those symbols. Some final thoughts before I give you a brief test on this. Very important to review your privacy notice regularly, and particularly in terms of your preparations for GDPR, one of the things that you need to prioritize is actually looking at your existing privacy notices and checking that they are going to comply with the needs in the new GDPR. So especially those set out at Article 13 and Article 14. So make sure that it's clear from your privacy notice make sure that you review your privacy notice to ensure that it complies with those new requirements. You need to keep records of how you develop your privacy notice so you can demonstrate to the Information Commissioner and others that you have actually taken steps to make your website and to make your privacy notices as useful and helpful to data subjects as possible. Remember, there's an emphasis on pushing information to users rather than pulling. So basically, you have to make sure that it's that however they access, however they're providing their information, that they are provided with information about what you're going to do with that data, and that they don't have to go searching for that information. So that might include the use of just-in-time notices. If you use your notice to obtain consent, so if you're asking people to tick a box, then you will also need to review that. You will need to review whether or not you can still rely on consent on the basis of your existing privacy notices, particularly if in the past you have been saying to people, unless you tick this box, we will assume that we are able to use your data in a particular way. If that's the case, then you will need to review what you're saying and just check that what you're doing is still going to comply with GDPR. If you want to know more about consent and about the other conditions, obviously we do provide other webinars on GDPR and other training courses on data protection in which that issue of consent is explored in more depth. So you may want to consider looking at the ACNOW website for details of those other courses to find out a bit more about that. But certainly one of the things you need to look at is consent. So, nobody's asked any questions of me so far. If you do think of any questions in the next few minutes, there's still time. Do just type those into the chat box. But in the meantime, I've got some questions for you. I have a test for you on privacy notices. I'll give you a couple of minutes to have a go at this, and then we'll review the answers together. First off, under the Data Protection Act, privacy notices ensure compliance with the lawfulness element of the first data protection principle. That's actually false. It's actually the fairness principle of the data protection of the first data protection principle. The second question: a sign with a CCTV symbol and the name of the data controller complies with DPA. False. No, you need to have more detail than that, and certainly under GDPR you need a lot more detail. 3, privacy notices are sometimes referred to as fair processing notices. That is of course true. 4, if you've got a detailed privacy policy on your website, this will be enough to meet requirements of fairness and transparency. That is false. You may need to go further, and particularly with GDPR, you'll need to think about how easy it is for people to access information about what you're going to do with their data. 5, the closest equivalent to the first data protection principle in the GDPR is the integrity and confidentiality principle. That's Article 5. That's false. The integrity and confidentiality principle is the equivalent of Principle 7, the security principle in data protection. No, there is a transparency, fairness, and privacy principle in the GDPR, which is the equivalent of that first data protection principle. 6, the provision of information in a privacy notice or equivalent is a right under GDPR, and that is true. 7, if someone chooses not to provide all the information your organisation asks them for, and this affects whether they will receive certain discounts, there will be no obligation on you to warn them of this. That's false. You are obliged, as part of the information you provide to people, to explain what the implications of not providing the information will be. And then finally, this one seemed to stump people, under GDPR you need to know exactly how long you will keep personal data for when you first collect it. False, you don't need to know exactly how long you'll keep it for, but you do need to know at the very least what criteria you will use to decide how long you're going to keep it for. So certainly you do need to know something about at least why you would decide to dispose of data. Okay, so thank you for having a go at that test. Hopefully it helped to reinforce some of the things that we've talked about over the last hour. Just to finish off now, just bear with me a moment. If you found this webcast useful, you may be interested in some of our other webinars, which are available via, details of which are available on the ACT-NOW website. There's lots more stuff on data protection, loads more webinars on GDPR if you're interested in learning more about that subject. Subject access requests, freedom of information, records management, all sorts of things covered by our webinars, and all of them are listed on the ACT-NOW website, so have a look there if you think those are of interest to you. If you want to get a qualification in data protection, there's a couple of qualifications that ACT-NOW offer. One is the British Computing Society's 6-week course on data protection, and there is an equivalent one on freedom of information run over 5 weeks with an exam, a 3-hour exam at the end. If you're interested in getting a qualification, that's one that's very widely recognised. Details of that can be found on the ACT-NOW website again, but also ACT-NOW offer a course which is much more aimed at GDPR and is a shorter course with a coursework element as well as an exam, and so that may be of interest to you. Again, details available on our website. If you want to contact ACT-NOW for any reason at all, those are our contact details, website at the bottom there of course, but you can email us or get in touch by telephone using the details here. It just remains for me to say thank you very much for your attendance on this webinar this afternoon. I hope it's been useful to you. I hope you've learned something you didn't know already, and it's given you some food for thought about privacy notices. In a few moments' time, you'll get asked for your feedback on this session. So please do fill the form in. It's always useful to know what you thought and if there's things that we can improve. But for now, thank you very much for your attendance this afternoon. I look forward to talking to you on future webinars and ACT-NOW training courses. And have a wonderful weekend. Thank you and bye-bye.